Hi, my name is Danielle Wright. I work for Hopkins Solicitors. I'm an employment solicitor.
We're going to talk about the subject of furlough. I'm sure up until a couple of weeks ago, that's a word that nobody would have even heard of. So what is furlough?
Okay, so this applies to the government's new initiative in respect of the coronavirus job retention scheme. So it enables businesses to cover the wages of their employees and basically place them on temporary leave, and that temporary leave is referred to as furlough.
And why would a business decide to put someone on furlough?
Well, as you can imagine, unfortunately, a lot of businesses have been affected quite significantly as a result of the pandemic, and where they may be making decisions in respect of possibly laying individuals off, placing them on short-time working or unpaid leave, or having to go as far as to possibly make redundancies. This scheme can be used to try and avoid that at this moment in time and keep individuals on their payroll, but not having the burden of paying their full salary during this difficult time.
Okay, and you say about not having that burden. So what support is given to businesses by the government to help with this?
Okay, so the scheme applies to employees and workers, so that could be zero-hour workers, fixed-term employees, agency workers. It also includes apprentices, but they're allowed to still carry out their training whilst furloughed, and the employer has to pay their national minimum wage and top up if necessary. But what the government is offering is 80% of their wages, basically, and covering that 80%. The employer can choose to top up to the 100%, but it's not actually required to do so. So initially we thought it was just basic salary. Just to clarify, it's their gross pay, and there is a cap of £2,500 per month, so 80% or that cap, whichever is the greater. But further clarification has come through to suggest that if there is compulsory commission payments or other contractual benefits, possibly car allowances, they can be included in this 80%. It's things that are non-monetary, such as a company car, which would fall outside of that. So it's those regular contractual payments that they're used to getting every month, is how we understand it, but that keeps getting clarified as the days go by. Just to clarify that you do need consent from the individual to place them on furlough leave. We're hoping that not many businesses will struggle with that, because particularly if it's an alternative to redundancy, but their status changed to that of a furlough employee, and they need to have that all confirmed in writing, and they need to keep that record for 5 years.
So in terms of the workers who have been furloughed by these businesses, when will the business be able to get hold of that money, the support that they're due by putting a worker on furlough?
We're expecting it to be end of April, so they can take advantage of the scheme from the 1st of March, so they can backdate payments as of the 1st of March for a period of 3 months. But in terms of putting it through HMRC and then HMRC checking it and making sure they're eligible, it's likely that the money isn't going to come through until the end of April.
If a business is kind of plodding along and doing okay at the moment and still trying to analyse what they're going to do, is there a deadline for putting a worker on furlough, or is that still open?
No, they can start the furlough whenever they want to in that 3-month period. It's possible that the 3-month period will be extended, but we don't know that as of yet. The minimum furlough period is 3 weeks, so it might be that a business doesn't need everybody to be placed on furlough leave, but doesn't need as many, so they could implement some kind of rotation system where so many are on furlough leave for 3 weeks, they go into work, and then others go onto the furlough leave for 3 weeks, and you can rotate that through that period. But at any point that a business feels they're struggling and they need to take advantage of it, they can just start it. Just bearing in mind they do need that consent, and they do need it documented in writing.
Okay, so minimum of 3 weeks. Obviously, it can be longer, and up to a maximum of 3 months, I think you said.
Yes.
So,
yes.
But if an employer decides to furlough someone for 5 weeks, for example, are they then can they change their mind after 3 weeks and try and bring that worker back, or do they need to stick to the period that they've agreed with that worker?
No, the control is in the hands of the employer. It's up to the employer whether they put someone on furlough leave or not. And when they have, it doesn't necessarily need to be for that full 3-month period. So if work picks up, fantastic. If they need those individuals back at work, they come back in and they carry on working as normal. But hopefully they will have drafted something that suggests that they will keep monitoring it, and it may be that the individuals need to come back sooner.
So this is where it's important to seek the right kind of advice on the agreement to make sure that you're not leaving yourselves exposed potentially.
Yeah, you do need letters that have specific information in them, because it is changing their status. You do need to make sure that you've got like a declaration that says that they're consenting to this, and then other bits of information in there, like you might rotate it, or you might bring them back in sooner. Whether you're going to top up to the 100%, because employers have a choice there. They don't have to, but they may want to. And whether at the end of that period they may have to think about redundancies or layoff, etc. All of that would be put in that letter.
So there's limited companies which have a sole director or 2 directors, and they've got no work on because of the situation. What can they do? Can they furlough themselves? And what are the kind of rules and restrictions on that?
What we know is that directors can be furloughed, so they can place themselves on furlough leave, and they're allowed to still carry out what's known as their statutory duties. So an example would be, filing information at Companies House. But if they were a very hands-on director that was, overseeing operations, then technically they're not supposed to be working. So all we have at the moment is directors can be furloughed. They shouldn't be working, but they can carry out their statutory duties.
Yeah, one of the things that came up as well that I've seen on that, and I'd just like to query, is one of the statutory duties of a director is to kind of market that business or to put the name out of that business. So again, from a director's perspective, if they was to furlough themselves as an employee, does that also mean that the director could potentially do a bit of publicity, networking, like virtual networking and marketing, or not?
I'd like to think so, as long as they can demonstrate that it's part of their statutory duties. Just have to bear in mind that there will be some claims that are made that are possibly not done under the right circumstances or don't meet the test. And HMRC will have the right to investigate claims, and it could be later on down the line that they'll make a decision that the claim wasn't, valid, etc. So I just bear that in mind. But as long as they can show that it was something that was part of their statutory duties, based on what we've had so far, it seems that they could possibly do that. Yes.
Whilst you're on furlough, you can't do any work for the business, but there are certain things you can do while you're on furlough leave. Can you just expand on that for us?
Yes, it seems to suggest that they could do voluntary work or training. So if that training is part of their own personal development, but that seems to be permitted. But businesses need to be making it absolutely clear that individuals aren't to be carrying out their normal day-to-day job. And those individuals shouldn't be generating any kind of income as a result of this.
One of the other interesting things from that point then, in terms of training, so this is a great opportunity for employers to upskill their staff, really. If people are just at home, and they've got capabilities to get onto online training, this sounds like a good opportunity to make sure people are doing skills development. Is there as part of the agreement with the employee, can the employer put clauses in there to almost state that they need to do certain business related training, or is that a step too far?
I can't see any reason why, if it is training and it isn't generating any income and it's more about their development, and it's saying, look, there's a great opportunity here for you to do some of that professional development training or training in a particular area whilst you're on furlough leave, then possibly that is something that can be agreed on a one-to-one basis.
Okay, great. We'll put some links below for all of that sort of stuff, for social media and how to follow you guys and get in touch and see the blog posts. So Fantastic. Thank you. Thanks once again,
Okay.
Danielle. Really appreciate your time.